Looks like everyone is ready. We're now here for the argument of Dorsey versus State of Iowa. And Dorsey is the appellant, and he is represented by Alexander Smith.
May it please the court, opposing counsel. There's two things that I want to talk about with the court here today. The first of which is that Mr. Dorsey's illegal sentence claim was denied on principles of res judicata because of a prior motion to correct a legal sentence where he should have been appointed counsel but was not. That should not have happened. The second is that Mr. Dorsey's sentence of life without the possibility of parole is cruel and unusual as applied to him because of the unique circumstances of his case, including his unique status of having most of the qualities we expect to have of juvenile defendants, and the fact that when he committed the offense, he was 18 years and 5 days old. On the first argument, res judicata typically applies between two parties when something is fully and fairly litigated and there's an adjudication. In this case, there was not an adjudication when that initial motion to correct a legal sentence was denied, and it was not fully and fairly adjudicated because he was not represented counsel. The courts ruled that when there's a motion to correct a legal sentence, that's a stage of the criminal proceeding. The Iowa Rules of Criminal Procedure require the district court to appoint a counsel in those positions so that they can assist with a motion to correct a legal sentence. Now that's very important because most motions to correct a legal sentence are filed by prisoners. They are people that are unrepresented. They start hearing about cases. They start using jailhouse lawyers. They file something that is typically just, please, someone help me out. I need counsel in this instance. Court, please appoint counsel. And Mr. Dorsey asked for that on his first motion to correct a legal sentence, and he was not given it. It is one of those instances that in most of the time, if that were to happen in any other case, it would be called structural error. In a PCR, if a court allows something to, if counsel allows the case to be dismissed because of time limitations, that's a structural error. The entire thing has to be done over again. It should not be given legitimacy in the form of res judicata that Mr. Dorsey was not given counsel in that case, and it was denied. The court should give no quarter to that.
The court's alternative holding that the illegal sentence claim failed in any event, even if res judicata didn't apply?
Your Honor. Now, the court has never extended Lyle or Sweets or any of the juvenile sentencing cases to anyone above the age of 18. And for that reason, many would say that this is a case that should also not be extended. However, I think in Mr. Dorsey's unique position, it should be. And that's because he has all of those factors we expect to see of juveniles. And juveniles are not given special constitutional status.
Mm-hmm. All of those factors in someone that's 25, say, should we follow your argument in that case?
I think it has to be taken on a case-by-case basis.
Counsel, is there, in your view, any upper bound or any upper limit where we can draw some line, someone that's 50?
Given on what we know about the neuroscience right now, like we think it's about the mid-20s where most people should be able to do it. At the very least, it's up to the age of 21. I mean, and I think we can at least extend it by a week in the case of Mr. Dorsey and the unique circumstances. Now, what's cruel and unusual changes. We know that from Lyle. It changes by societal standards, and it will also change by what we know about the neuroscience. And so that can, I think, change in the future, but it might also be something where the court says, well, we really do not know enough about that right now. And so no, for right, not for right now, we're not going to do that.
Action, like I think Nebraska goes up to 19, for example. Juvenile is defined as someone through the age of 19. Isn't this something legislative that you're, in a sense, asking us to do?
No, because cruel and unusual really does have a normative judgment in it. The court does have to make a normative judgment about what is right and wrong, what is cruel and unusual, and that feels legislative, but it's also the responsibility of this court to do.
Indicator of what a normative or what community values are, the enactments of our elected legislators?
Your Honor, I mean, you can take a look at how society progresses and what the societal attitudes are, and it might be the case that the legislature, or for whatever reason, has not updated those to current society values, and there's many different reasons that they might have that. In those circumstances, the people of the state of Iowa have a constitution that says that they're protected from cruel and unusual punishment, and the other people in their state are also protected from cruel and unusual punishment, and that they believe that they are living under those laws, and the court has to protect them.
If I can, a little bit about the science. In 2016, Scott and Steinberg et al., I mean, some of the leading experts in the field, Richard Bonney as well, published an article, and they basically said that it's not a binary question. It's not a binary question of juvenile versus adult, and that there's really kind of a third category. I'm paraphrasing a little bit. The third category might be characterized as maybe youthful offenders. There seems to be a suggestion in the article that while the science is firm up to 18, it gets somewhat thinner as one advances. What do you make of that? What is the real state of the science for people beyond age 18?
Pretty clear that you know, up until age 18, like most people will follow along a similar trajectory, and then people start splitting up after the age of 18, and they're in sort of positions where some of them, yes, full adults, they're good, they can go and get college degrees, go to law school, you know, that they are on the path to adulthood. Other people take more time.
And let me kind of follow up. You do have a Brugger-type attack. Nobody questions that. Now, that's different than the law for people that are under 18. But under Brugger, there is an as-applied attack as cruel and unusual. And in that attack, you can present all the science and so forth. So I guess my question is why isn't the Brugger remedy adequate in your case?
Remedy would be adequate in my case. I think that's why I was saying earlier, you can take it on a case-by-case basis. And you can say, all right, look, a lot of people that are 18, they need to be treated as adults. They're fully responsible. But you look at someone like Mr. Dorsey and his actual circumstances that he was living in when he was just out of juvenile court jurisdiction when he committed this offense, how he was growing up, and say, this guy in particular. Now, I have to ask for an exception to the general rule for that, and so I am in some sense attacking the general rule.
Science at all relevant to the question?
Relevant to the question because it was relevant in Lyle and it was Sweet, and we looked at who these defendants were and what you know, they were actually responsible for, and the issue of culpability.
Does, and the literature talks about the decision-making process and how that's done, but culpability, responsibility are legal terms that are independent of that. And if, as a society, we say that persons over the age of 18 are fully culpable for their conduct, period, that's not a science question, that's a legal determination. So why is the science at all relevant?
Actually related, Your Honor. I think that someone who is fully developed and fully has that science, and they fully know what they're doing is more culpable than somebody else. And I think that the court has to get into that question when determining whether something's cruel and unusual. We could also, as a society, say before Lyle that, well, it's still okay to give them life with the possibility of parole.
The waiver and reverse waiver procedures that are already set forth in the code that determine whether or not somebody will be charged as a juvenile or an adult, why aren't those sufficient to draw distinctions between people who maybe should be treated with less severity or greater severity versus this constitutional argument that you're making?
Court as a whole is a statutory creation. And so if it doesn't exist for someone and the reverse waiver or waiver hearing is not available for them, then they do have to resort to making constitutional claims about what's cruel and unusual. If
The dissent that was in Bruger, it kind of goes along the lines of what I was asking about earlier, that the sentencing policies of today are our policies and the product of our legislature as representative of the people. Can you comment on that? Try and help me understand how you're getting beyond the legislative indication of what is defined as a juvenile.
Honor, I think that the court has a responsibility to determine what's cruel and unusual, and that people of the state of Iowa also have ratified their constitution. And so it's not just a matter of whether they place in their trust in these legislatures, they also place their trust in the Constitution. And so whether the average person knows it or not about what their legislators are doing or understands the particular sentencing procedures that they're being given, they know at the very least that they have constitutional rights, and one of them is the right to not have a cruel and unusual punishment against them or any of their fellow citizens.
There's a threshold requirement to establish cruel and unusual punishment, and it basically says, well, before you get a hearing on all their facts and circumstances and so forth, there has to be kind of I'll characterize it as a preliminary showing or threshold of disproportionality. Here, one can argue the crime is heinous enough that you don't pass that threshold. This is not a remote felony murder, for example, where the involvement was arguably lesser. Make your argument, if you will, that you've crossed the threshold of disproportionality.
So one of those factors to be looked at is the unique circumstances of the offense, right? And this is why I was so important to appoint counsel on motions to correct a legal sentence, because just the unique circumstances of an offense can pass that disproportionality test. And that review, as stated in Bruger, is not toothless. I mean, a lot of those principles are going to apply to any case. And so some of those unique circumstances are really what's going to push something over into being disproportionate.
This case.
It's all the features of youth that we saw in our juvenile sentencing cases.
Of this crime.
So this took place right after Mr. Dorsey turned 18. He was at a party. He was intoxicated. He had grown up in a very poor home environment. His parents had been divorced. He had been dealing with drugs and alcohol while he was a teenager. And throughout that time, he had been in this boy's...
Most everything you've just cited is like most kids who have been in trouble with the legal system. So keep going, but I just wanted to point that out, that not too terribly unique.
It's not unique. They're the features of youth. We're all lucky we didn't make such poor decisions. With two other individuals, right? And so he was subject to some of the peer pressure and the impetuous and reckless decision-making that we see from juvenile offenders. So he was with them. He actually was trying to confront somebody else. And when he did not find them, took it out on the victim in this offense. He was upset and angry. I mean, is basically what the record evidence seems to indicate.
And to complete what happened that night, I mean, what happened to the victim? Right. And how? Face?
Awful heinous crime, Your Honor. I'm not ashamed to admit it.
Statistics are relating to homicide rates for juveniles versus non-juveniles. If the data showed that juveniles who allegedly have horrible decision-making capabilities and shouldn't be held responsible actually commit homicides at a lesser rate than adult offenders?
To do with the deterrence rationale for punishing juveniles. And it would have to be, like, we have to go back and look at how good they are at making decisions, right? And they aren't very good. They don't know about there's really no deterrence value added to punishing juveniles. And so looking at
We're going to get into the science. Some of the science indicates that juveniles are impetuous. They make bad decisions. But the science relates to things like shoplifting, getting into fistfights, vandalism. do you have some good evidence or evidence in this record that indicates that same kind of decision-making extends to, in this case, murder?
I don't think on this record that we do, because it was dismissed on summary disposition, but I think that a lot of that evidence is in the court's prior juvenile sentencing cases. I see that my time is up. Thank you.
Thank you, Madam Chief Justice, and may it please the court. Counsel, good morning. It's a privilege to be here. I think that the substantive claim of cruel and unusual punishment, the way I read the briefing, there were two separate claims. One, a categorical challenge to the mandatory imposition of life without parole on an adult offender. And the second is the claim that was discussed here, the as-applied challenge. Now, the court didn't really rule on an as-applied challenge. You can tell because it said res judicata. This is the claim that was raised and resolved in 2014. I think this record is already clear enough to rule that there cannot be an as-applied gross disproportionality challenge here, similar to Wicks, similar to Oliver, where the record already established forecloses any inference of gross disproportionality by a convergence of unique factors. And one of the first things that you have to consider in that is the severity of the offense, the retribution rationale, the gravity of the crime, the harm to the victim and the community. This is, as was pointed out, not a felony murder from Mr. Dorsey. This is a
Murder would be a much different situation, you'd agree, or at least a different situation.
I would invite this court to say that there can be no gross disproportionality in a life without parole sentence for first-degree murder, for a deliberate premeditated murder for an adult. And the principle may extend further, but this court could just say that.
I think the defendant makes a pretty good point in the reply brief that retribution, which some of us, including me, have always assumed is a permissible sentencing factor, isn't mentioned in 901.5.
As something that guides the exercise of court discretion in selecting between legislatively authorized sentences, but retribution is a key motivating factor in the, I think you read it into the legislative prescription of punishments, both ranges available for different crimes and the mandatory imposition for certain crimes, that there's a clear retributive thrust. Now, I think that that's a interesting point when raised in the reply brief too. It concedes that if authorized by the legislature, if the statute had said retribution, then it would be something that sentencing courts would consider in their exercise of discretion. And I think that we have said previously, or this court's opinions have said that sentencing courts may consider retribution in giving voice to the harm of the offense and the punishment merited. But I also think the legislature has enacted its view of the need for retribution for these offenses by saying mandatory life without parole, by confiscating this particular kind of offense, punishment for it, from that exercise of discretion under 901.5 that says consider rehabilitation, consider the specific and general deterrence. The legislature says don't do that. The legislature wants to advance a view of the retributive demand for punishment, not because of the policy consequences of it, but because the harm visited upon the victim and the community demands it. I also think that in the constitutional analysis of whether something is cruel and unusual punishment, 901.5 doesn't really enter into that analysis. We still use the same threshold comparison of the gravity of the offense, the severity of the harm versus the punishment. So regardless of what 901.5 says, we still consider retribution, the severity of the offense, in that threshold Brugger analysis. I think that when I read the briefing, and I recognize that Brugger sets out a general framework. It's not a three-part checklist that you have to hit each of these individual facts to have a Brugger claim. But what I think Brugger is about is finding a unique convergence of factors that geometrically amplify the liability in a way that wasn't what the legislature intended to capture target and criminalize with the criminal prescription. And this is the crime that the legislature intended to criminalize. This is a deliberate, intentional killing. It's squarely within the authorized legislative zone. And I think that that embodies a very clear community judgment of the appropriate punishment for a deliberate, intentional killing. And that creates a really high hurdle in our constitutional order for the judiciary to override it and substitute its own judgment. The community has said and has repeatedly, refused to back down from the expression of its view that life without parole is the only suitable punishment for an adult who commits a deliberate, intentional killing.
With felony murder too, right?
Yes, that's true.
I have a real problem with that, likely. Depending, admittedly, I think, on the facts and circumstances of the case. In a life imprisonment for a felony murder that might involve a person who's 18 and a half and might have other extenuating circumstances might well, under Brugger, amount to cruel and unusual, or at least cross the threshold, put it that way.
To Harrison, but I also think that we can discuss that claim when it arises. In this case, and I also want to add to the discussion of the facts, Mr. Dorsey missed with his first shot and reloaded the shotgun, pursued the victim, and then shot her in the face. And the reason that he shot her wasn't just generic frustration. It's because he was hunting her son and she refused to reveal his whereabouts. So I don't think it's necessary to go that far into the facts in order to say there's no Brugger claim here. I think it's helpful to illustrate that there just can't be one. But I also think that it's supported in the law for this court to just say no gross disproportionality for a life without parole sentence for an adult who commits a deliberate premeditated killing. There's an interesting procedural issue as to the res judicata argument. Now, I understand this to be kind of a two-pronged attack on res judicata. First is that it wasn't fully and fairly litigated, and second is that the ruling in 2014 wasn't an adjudication. I think that most of the time when we have these motions to correct illegal sentences, they're after Lyle, when a juvenile challenges their sentence, they're using one of the exceptions in, even if they had previously filed a motion to correct a legal sentence, they're using one of the exceptions in section 28 of the restatement second on judgments, pointing to a change in the intervening law. Now or change in the applicable law, that change in the law has to be substantive and retroactively applicable for this to work. And in Lyle's case, it was. Here, we don't have that. Lyle very clearly says it's not applicable to 18-year-olds, and so do all of our juvenile sentencing cases. Now, for the fair
claim. Surely, if a lawyer had been appointed in the first proceeding, there would have been an opportunity to explore what we're exploring here today. Correct? And it's not a frivolous claim.
Foreclosed into the state of the law, and the district court was right to say so. Now, that denial of appointment of counsel could have been challenged. Now, I know that he didn't have an attorney, so maybe he shouldn't be expected to know that he needed a petition for writ of certiorari, but I mean, at the time, the law wasn't even that clear that that's what it was. But he could file a notice of appeal, and this court could treat it however it wanted to. That's how Jefferson happened.
Necessarily an unreasonable extension of Lyle, especially given the dissenter's position in that case, that if you took the logic of Lyle, you would necessarily have to extend it to potentially 25-year-olds. That seems to me to be a sufficiently new kind of claim that maybe res judicata wouldn't apply. What's your response to that?
If that's what this court says and wants to reach the claim on that, then I think that it could say that. I think when I look at it, I see this as the same claim that was raised in 2014. Now, if this court wants to say that there is an intervening change in the law that raised a question and made the claim potentially meritorious, that's one thing. But I don't think that that's the kind of change in the law that can subvert the application of claim preclusion. And that's the reason for most of our notice of additional authorities is that I actually think it's very interesting, the argument that under props, this ruling isn't a final judgment and therefore can't be an adjudication. But if that's accurate, then no ruling on a motion to correct a legal sentence can ever have claim preclusive value. And I don't think that that can be right. So various states, now a lot of states will say a broad statement like res judicata doesn't apply to motions to correct a legal sentence. What they mean is a broader version of res judicata where if you had an opportunity to raise the claim and you didn't raise it before, then you can't raise it again. Something similar to our A22-8.
The area in general, because even with regard to PCR, I mean, PCR is an exception to res judicata, really. I mean, the conviction's final. You're now challenging the conviction and saying it's not final. So it is kind of a dicey thing. What do you make of the fact that Judge Stayskull only mentioned the United States Constitution in his ruling? And obviously, clearly here, we're dealing with the Iowa Constitution. There's no basis for a claim here under the United States Constitution.
I think that's a ground that you could say that this is a different claim. You could say that. That's not what was said below. What was said below is that res judicata doesn't apply because there was no appointment of counsel. Now that I think is not a valid ground. There is an exception in Section 28 of the Restatement Second of Judgments, the very last exception that says res judicata may not apply if there's not an opportunity for a full and fair adjudication on the merits of the claim. But there was an opportunity for that, and that full and fair adjudication on the merits did happen. The court said, this does not state a claim under the current state of the law. These cases just have no applicability whatsoever to 18-year-olds. Now, that was a full adjudication of the claim. If intervening legal developments have changed the law, that might be one thing, but that was a fair and full adjudication of the claim as it existed at the time, and there was no even notice of appeal or any filing after it to challenge it, nothing that would have enabled another court to review either that ruling or the denial of counsel. And that's one thing that I think is important to note is that even in motions to correct a legal sentence, even where courts say the phrase like res judicata doesn't apply, they almost always have some version of claim preclusion still. Kansas says a motion to correct a legal sentence can't breathe new life into an issue already decided. And I think that what Florida calls this Idaho calls this in Shanahan is true res judicata. I think they're referring to claim preclusion where the exact same claim was decided already. That has preclusive value. But like PCR,
Practicing before ADIPA, they had this old concept of abuse of the writ in federal court. And it's almost like that's kind of what we're talking about because it does seem like you can raise a motion to correct a legal sentence at any time. And if you have something new to say, that's truly new and might be meritorious, we don't want to prevent that.
what I'm saying is that when courts say res judicata doesn't apply to motions to correct a legal sentence, they mean that. They mean if you're raising a claim for the first time, it doesn't matter that you could have raised it earlier. You can raise it at any time via motion to correct a legal sentence. What I'm saying is that if you've raised this exact claim before, there should be some claim preclusive value to the ruling that you got that time. And I think that's consistent with the way that other courts have treated prior rulings, successive motions to correct a legal sentence on the same.
It's cruel and unusual. Can you envision and totally make it up? Can you give us a set of facts where somebody beyond 5 days beyond 18 might just actually be a good candidate for the relief being sought by Mr. Smith?
It would be difficult because the legislature has specifically set out these conditions for to trigger the imposition of this mandatory sentence. I would probably start with felony murder. Then I would add joint criminal conduct where they participated in one offense and the murder was maybe foreseeable and the jury finds it reasonably foreseeable. And I would add severe intoxication. Now, aiding and abetting, you have to share the specific intent of the actor. If you aid and abet a killing, right? So I would say joint criminal conduct is my recipe for that. Add in some severe intoxication. I mean, and then it's going to be a close case for me. And I think that if the legislature wants any exception that this court would try to carve out would be flying in the face of the community judgment expressed through the legislature that declined to draw such an exception.
The court draws the ultimate line on cruel and unusual punishment when it becomes certainly grossly disproportionate. That's a line for the court to draw. I mean, it's a provision of the Constitution. Otherwise, I mean, we could say, if we wanted to defer the legislature, we could just take our black pen and write out the provision of the Constitution. So it's there. It's a question of really what do you have to show, and how do you draw the line? I mean, this is line drawing everywhere, actually. I think. How do you draw the line between what amounts to a permissible judgment and what does not? And where that line draws, ultimately, the court has a role.
Was expired. Thank you. So you're right that the court has a role. That role is to intervene when a punishment becomes so cruel and unusual that it shocks the conscience, that the legislature cannot, in its exercise of community judgment, consistent with human decency, impose that punishment. Now, the problem is with first-degree murder, even with felony murder, you're always dealing with the problem of a life has been taken, the community has been diminished, and that harm, that outrage. If you look back in history, I mean, Justice Mansfield, I think it was your dissent in Lyle, if I'm not mistaken, that historically this, even for a juvenile, could be punished by death. And I'm not saying that's what we want. I'm not saying that would pass muster today, but I'm saying that it doesn't shock the conscience to say the penalty even for participation in a deliberate intentional killing is life without parole, in recognition of the harm to the community, the victim's family, the lost life, and the hole that it leaves behind, and the transgression against the community values that represents, the wrongfulness of it.
Agree. The question is, where do you draw the line?
And I think that, who decides is really the heart of it. And I think that this court's jurisprudence on cruel and unusual punishment is that in almost every circumstance, it should be the legislature. And this is not a circumstance where that should be subverted. Thank you.
The question before you even get going. So piggybacking off of what I just asked opposing counsel, would you agree with me that those circumstances that you articulated for your client are probably 95% the same circumstances of many, many, many people incarcerated for a similar crime? Okay, so then could they come back and make the same argument and say, yeah, I was beyond 18, but only by 8 days or 18 days or 18 weeks or 18 months? What do we do?
That is what Brugger demands, is sort of individualized and bringing up unique circumstances.
Everybody incarcerated?
They all can file motions to correct a legal sentence, and they all can.
I mean, even under Brugger, there's a kind of a threshold. I mean, Brugger didn't find, by the way, that the sentence was cruel and unusual. There was remand back, and Brugger basically said that under the factual circumstances of that case, the threshold had been crossed. But there's a Rubicon, if you will, you got to get across it. So run-of-the-mill cases might not make it. And isn't the burden on you to show that this is an exceptional case?
So, Your Honor, and I think the fact that it's a weak difference between Mr. Dorsey being in prison for the rest of his life and Mr. Dorsey having the potential to leave one day.
That's an interesting point, but I don't really see that as part of the Brugger analysis. I mean, Brugger, which then we carried on, and I think it was Oliver, where there was a sex offender who was facing life in prison. I mean, we make a threshold comparison of what the person did to the punishment being received before we look at anything else. The Lyle, Ragland's Null line of analysis, that's a different line of analysis. That says if you're under 18, then you get a whole hearing on the 5 factors before you can possibly receive a mandatory minimum of any kind. So those are really 2 different things. They don't really blend into each other as I see it. Am I missing something?
circumstances of the case is one of those Brugger analysis that the court has said to look at. And so I think those things can come up in the unique circumstances of the case because the court isn't limited at what it can look at. So we can look at, it's like, you know, this weak difference between life in prison and not life in prison without the possibility of parole. That's fairly arbitrary. It can look and say, look, all these things that we say make these life without parole sentences of juveniles something morally wrong, make them cruel and unusual. They all exist for this guy too. The court can take a look at those and see if that is going to overcome the Brugger threshold.
The record, and I haven't had a chance to see it, but at sentencing, of course, even though juvenile records are confidential, a sentencing judge, when somebody is an adult, is entitled to review everything. What was in his criminal history before 18? Was there felonies or anything like that?
I can't remember, Your Honor, what we had. I mean, because we didn't have to have we didn't have the full record, and so basically I had to look through the old PSI and figure out what it was. I don't remember it being super awful felonies or anything like that. But he did have a variety of past criminal contact, and he was definitely at the Boys State Training School, so he was definitely dealing with all the effects of that.
Place there.
No, he had a tough childhood. I mean, like I said, he was addicted to drugs and.
That's why they're there. They have a tough childhood. So I'm trying to figure out from you what is unique about this situation.
I think what makes it unique is just his age, right? I think that he had all the qualities of someone who is 17, 364 days old, and he was a couple days over. I think that's what is unique about this. And we would say, yes, it's morally wrong. The court has said it's morally wrong. It is cruel and unusual to give this person a sentence of life without the possibility of parole 1 week before. What changed? Nothing changed other than we as a society put a lot of emphasis on the number 18. That's the only thing.
I think your argument would be stronger, would you not agree, if he was 18 days and 18 years, 5 days old, and this was the only thing your guy had ever done. But if he went to the state training school, doesn't that set him apart from your typical juvenile type offender?
It actually shows that he had a lot of the features and recklessness of youth, and that he was still laboring under them and still dealing with those processes. I see that I'm out of time, Your Honor. Thank you.
Dorsey versus State is hereby submitted as well.
And court is adjourned for the morning.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.